Hello, everyone. I am Humera Ahmed, the VP of Legal and Business Development at the Liberian Registry. And today we're going to be talking about financing charters with Frank Nolan and G. Kim. Both are shareholders at the law firm of Vedder Price. A brief introduction. Frank Nolan is based in the New York office of Vedder Price. He has extensive experience with operating leases and leveraged and synthetic leasing structures. He also represents clients in financing transactions for vessels under numerous foreign flags and bareboat charter registries, including the Liberian Registry. And most importantly, he assisted Liberia in 2018 with drafting provisions in its maritime law relating to financing charters, which is the topic of today's discussion. Frank is also the immediate past president of the Maritime Law Association and the legal advisor to the U.S. delegation for the UNICITRAL Convention on the Recognition of Foreign Judicial Sales of Vessels. Moving on to G. Kim. G established a Singapore office of Vedder Price in 2016, and he is currently based in Singapore. G has extensive experience in equipment finance matters involving both aircraft and maritime assets, and he represents commercial banks, lenders, and others on cross-border leveraged leases, mortgage financings, bareboat charter financings, sale leasebacks, and capital market financings. Gentlemen, thank you for joining me today in this Q&A on financing charters. So before we take a deep dive in financing charters, Frank, perhaps you can set the stage and provide a brief history of traditional ship financing.
Well, thank you, Humera. Traditional ship financing really has changed over the years from the middle of the 19th century with the advent of steam replacing over time sail. Back in the days of clipper ships, investors would finance ships that could be repaid in their entirety with a single one-way voyage to China or the reverse. Then with the industrialization of ships, it became harder to do and became far more capital intensive to the point where today it's extremely capital intensive. And the way that became doable was by the creation of the ship mortgage. And the ship mortgage replaced the individual investors' equity and the bottom-rate bonds that were used here and there, and created a privileged position in the collateral so that a ship could be financed over a period and amortized over a period of years and not simply on the basis of a single voyage. So the ship mortgage, which first arrived in England and Western Europe, enabled the expansion of the industrial shipping sector that we knew until the middle of the 20th century. But the shipping industry has continued to be a big consumer of capital and with challenged balance sheets, as everyone knows. So today, that's what really brings us up to the point of, excuse me, of the finance leases. And this is just another step in the process of trying to make capital more available to the shipping industry.
Now, let's get into financing charters. What exactly, G, is a financing charter, and how has this financing structure been used, and how has it grown in the shipping sector?
Certainly, I can take that question, Humera. I appreciate the opportunity to have this conversation with you and with Frank today. So what is a finance charter? We could call it a finance charter or a finance lease. That's typically when in our shipping sector, when there's a ship owner that perhaps owns a ship, and in the context of perhaps a sale leaseback where they transfer title to a financier, and then that financier leases the asset, the ship, back to the ship owner under typically a bareboat charter. Or if it's a new build, for example, the ship owner may request the financier to purchase the vessel directly from the shipbuilder and then enter into a lease. The end result being that there's a purchase aspect of it and then a lease aspect of it. With the financier chartering the ship back to the ship owner. Typically, there's no recordation of that charter, which is the big point of discussion today. There's no preferred ship mortgage in that structure. And of course, because you don't have a preferred ship mortgage, there's no preferred mortgage lien that's relevant in a typical finance lease structure. The finance lease tend to be typically longer. They're long-term financings. They cover a substantial part of the ship's economic life, and they usually fully amortize, which includes that financier's return on his investment. So, and ultimately, the quickest way to think about finance charters is that all the risks and rewards typically are transferred to the ship owner, the lessee in this context. And this financing, this type of variable charter financings, as we know, are widely used in today's ship financing. And that's been really spurred by the rise of the Chinese leasing companies in the last 5 to 7 years. What was originally thought of as an alternative form of financing during the downturn where the traditional banks left the market, and the Chinese leasing houses came in, utilized ship finance, the finance charter structure to provide the financing that's needed. Now that has developed over the last handful of years to what was originally alternative to a mainstream financing where bulk, if not all, of the portfolios that's been generated by the big Chinese leasing companies are structured in a finance lease structure. So, they're big. These are relevant structures that we find. And as Frank mentioned earlier, it's the natural evolution of the ship financing that we find in the market today. So it's something that we certainly need to be cognizant of because of the play that, especially with the advent of the Chinese leasing houses.
Thank you for that explanation. Now focusing on Liberia, Frank, as you know, the Republic of Liberia amended its laws to allow for the recording of financing charters in 2018, and you were instrumental in such efforts. Currently, the Liberian Registry has over 20 financing charters recorded with the registry today, and this number is continuing to grow. And perhaps, Frank, you can explain what led to the development and the amendment to Liberia's maritime law to allow lease financing structures to be recorded as a mortgage.
Well, Humera, this is one of my favorite long stories. I'll try to shrink it. But in the late 1990s and early 2000s, I was chair of the Marine Finance Committee of the United States MLA. And we started to ask the question about why was leasing so underused in the shipping world when it predominated in aircraft finance and was almost the exclusive way to finance rail cars and other types of mobile equipment. And so we looked at the elements in the history. A lot of it had to do with the history, but we decided that the best way to do it was to look at the way to make a financing lease to be treated as a preferred mortgage. And so we did this actually initially in the context of United States law. And we drafted a proposal and we shopped it around Washington and with who was sort of indifferent to it. So in the early 2000s, I'd say mid 2000s, I was at a Marine Money Conference and I ran into Clay Maitland of International Registries, the Marshall Islands manager, and Brad Berman of Lisker. And I said, gentlemen, it occurs to me that maybe the true market for this is the open registries, and you have the most nimble registries in the shipping world. So you should really look at the possibility of adapting this concept of a finance lease to be treated as a preferred mortgage, adapted into your statutes, because you really are the registry for the vast bulk of advanced vessels in the open seas.
The requirements under Liberian law to record a financing charter with the Liberian Registry are pretty simple, and they're not too far off from what's required to record a mortgage. Are there some other legal considerations and issues to consider when recording a financing charter? Frank, perhaps you can take that as well.
Well, in financing in adopting a charter, which is a financing charter, or could possibly be construed as a financing charter, to the Liberian statute or to the Marshall Islands statute, it's necessary to conform to the statutory requirements, which are also reflected in the regulations. And the reason for that is to bring it within the scope of international convention and the standards for recognition of foreign mortgages in states where they may have to be enforced. So this, for example, requires, in the case of an existing charter, that it be modified to include those provisions and be signed by both the owner, the title holding owner, and the charterer, who is the lessee. In doing it, I think the decision has to be made in bareboat charter situation, whether by degree of transfer of interest from the lessor to the lessee, from the owner to the charterer, it is sufficient to warrant the conclusion that it could be construed as a financing charter and perhaps a security agreement, which I think is a question that G is going to consider later on in this cast.
Moving on to recharacterization risk and forum shopping and bankruptcy. G, perhaps you can explain what is it and how does this affect lessors in a financing charter?
Yeah, happy to do so. So what is recharacterization? And that's a very nice segue, Frank, to what Frank mentioned at the end about how, you know, the various legal elements needs to kind of tie in with what you would normally expect. So that takes us to recharacterization. So what is it? So recharacterization is an equitable remedy that courts can deploy, typically in a bankruptcy scenario, when a transaction's form doesn't align with its substance. So what does that actually mean? Let's take the context of a sale leaseback, which is a context that we are very familiar with in the shipping industry, right? Where we explained that earlier. So typically in a sale leaseback arrangement, one party, the ship owner, sells the property, the ship, to a purchaser, which in this case would be a financier, and then leases it back from the financier for a long term. In these circumstances, given the facts of that structure, the bankruptcy court might recharacterize that leasing arrangement as a disguised form of financing, where the purchaser, in this case the financier, is really providing a loan and taking a security in the form of an ownership interest. So, you know, even though you structured it as a charter arrangement, the court recharacterizes it as a secured loan. So if the lessee in this context under that arrangement files for bankruptcy protection, let's say in the US, the sale leaseback arrangement itself would be challenged, or may be challenged, and the bankruptcy court would need to start evaluating whether that charter arrangement is a true lease or a disguised finance. And there's consequences to that. And that's the reason why recharacterization is often what we would consider a threat in our shipping bankruptcies. And you see that especially in the US. So it's definitely something that the industry participants in our shipping sector needs to be cognizant of that possibility. So then what are the risks and impact? So the recharacterization could have a significant negative impact on an owner, lessor. So if the bankruptcy court does in fact suggest that it is a disguised financing, then it would deem that vessel to be property of the lessee, the debtor in that context, rather than the owner, the financier. And if it does get recharacterized, it's very possible that the lessee would try to seek to reclaim that property because of that recharacterization, because in their argument, they would own it, right, rather than the financier. And typically in a US bankruptcy context, the treatment of lessors, the owners in a leasing arrangement, tends to be what we would consider a bit more superior than the holder of secured claims. So, and we can hit upon this a bit later, but if you had if lessors had a choice between becoming a secured lender in a bankruptcy scenario versus being a lessor, an owner, they would generally tend to want to be an owner, but by recharacterization, they lose all those benefits. So then in that context, if they do get recharacterized and the lessor is deemed to be a financier, a lender in a secured loan scenario, then what protections do they have? Well, what they most likely have is a security interest hasn't been perfected because there hasn't been any filings. They didn't anticipate this, right? So because they were relying on title as their security rather than a mortgage. So that in effect, that claim that they would have, that lien that they would have because of recharacterization would be deemed unsecured. And as we all are familiar in the bankruptcy scenario, an unsecured claim are entitled to a lower priority in the bankruptcy case, and often unsecured creditors only claim pennies on a dollar, right? In a claim scenario, so that's a negative impact on the potential risks that a lessor owner may have in a financing structure. So before I get to the sort of the forum shopping in the bankruptcy, Frank, did you have anything to add on the recharacterization issue here?
Well, gee, what I wanted to just point out, and maybe you're going to pick this up a little more, was why should all of these owners and lessors in Asia or Europe or Middle East care about what would happen in a U.S. bankruptcy proceeding? And I think that's really the $64,000 question here. The reason they care is because, as I mentioned in Singapore at that Marine Money Conference, the ship can travel anywhere. The ship could find itself arrested in Los Angeles and have these issues decided, and then proceed to a bankruptcy or foreclosure, and then have these issues decided of what is the nature of this charter. Is it a security agreement or is it a charter? In addition to that, we have the phenomenon now of what is called bankruptcy tourism, where the United States law is very accessible to foreign interests with minimal contacts in the United States. And a very large number of foreign flag ships have been processed through American bankruptcy courts for the advantages of a restructuring, which is not available in all systems. So my point really is to just reinforce what G said. These issues are not just issues within the American legal world. This is a worldwide issue.
Yeah, absolutely, Frank. And I think that's a nice sort of a segue to the sort of what you call bankruptcy tourism. I mean, there is quite a bit of bankruptcy forum shopping that goes on, especially in today's environment where COVID, there are more defaults. We are seeing more bankruptcies, and that's the reality of the world. But commerce does continue, right? And Humera, if I'm not mistaken, much of quite a substantial portion of the vessels that are flagged in Liberia do travel to the U.S. and quite a bit of the tanker market travels to the U.S. And anytime you get arrested, if a ship does get arrested in the U.S., and as Frank mentioned, the U.S. bankruptcy rules are very debtor friendly. We see this today where whether it's in the UK or here in Singapore or in other jurisdictions where they're amending their bankruptcy administration rules to almost make it more appetizing for debtors to file because of the influence that the US have had. They've seen that how debtor friendly the US bankruptcy rules can be, and there are other jurisdictions following suit. So this tourism idea that Frank just mentioned is a reality, and it will continue to be a reality. And as long as our ships are continue to be international, and as they continue to travel to and fro from the U.S.,
That's good.
Everything that we're discussing today is a reality, and we do see more of this, especially in the context of today, where we are seeing more defaults, more bankruptcies, and the U.S. is a very common preferred jurisdiction for ship owners and operators, which takes into play everything that we're discussing.
Thank you. You guys both briefly touched on the benefits of recording a financing charter, but maybe in a nutshell for the audience, if you can just reiterate the benefits of recording a financing charter with the Liberian Registry.
Sure. I can start on this one, Humera. So, and Frank has very eloquently already, told us the story of the background, how this this concept has been built into the rules and regulations in Liberia and the benefits of it. But I like to think of this in very simple terms. Yes, you've structured your deal as a bareboat charter financing. You want all the benefits of ownership and title, but it doesn't hurt to have a backup system, right? In today's climate, and you basically, by filing it, you get the benefit of a mortgage, right? Of a preferred mortgage status. So even in the event that your leasing arrangement was recharacterized as a financing, the lessor would have an effective security interest in their asset and would be accorded the status of a secured creditor. And this would be a significant improvement in their position in a potential U.S. bankruptcy scenario. As we know, secured creditors are entitled to recover in a bankruptcy scenario the value of their collateral, versus, as we mentioned earlier, an unsecured creditor only tends to get cents in a dollar, right? And so from not only from a risk perspective, but from a business perspective and from a commercial perspective, what position do you want to be on? Make the extra filing, use the benefits that the flag is offering you because yes, is there an extra step that you need to do? Yes, you need to file. But if you think about it from the context of the cost benefit context and what's the consequences of being a unsecured creditor versus a secured creditor, I mean, that's night and day, right? And the consequence of that. And I think it's a no-brainer for a lot of commercial players, lessors in our sector to seriously consider this. Frank, anything to add to the benefits there?
Yes, I think, and it's well said, G. I think the thing to remember here is that the animating principle that drove this whole discussion was how to bring more capital into shipping. That shipping doesn't have the kinds of balance sheets generally that allow unsecured lending, although we see some of it in certain sectors. So the idea was to enhance the position of financing parties entering into leasing transactions in order to encourage them to do so, which ultimately falls to the benefit of the ship owner operator. So this is the advantage. The advantage is not in any individual charter where a charterer is going to be prejudiced because lessor now has a mortgage. The real issue is if this product isn't used in a lot of situations, the lessor will never agree to lease the vessel to the charterer in the first place. So that's really the advantage of the provisions of the Liberian law and also the Marshall Islands law. But this product, I think, is a way to bring ship finance further along to the kinds of flexibility and the expansive capital investment that the airline industry's had and container industry.
So ultimately increases capital to the ship owner. In terms of Liberian laws and regulations for financing charters, Frank, perhaps you can explain, how are they different from other laws typically found in the shipping sector?
Well, Humera, it's easy. There ain't none.
Yeah.
There are none, and we've been approached indirectly by interests in the Panama flag to advice on how they could do this, but they are really not committed to the same underlying legal principles that we have used in drafting these for the Marshall Islands and Liberia. Jurisdictions that are very literal in their characterization, that if it's called something, if you call it something, that's what we'll call it. So that if it's called a charter, we'll agree it's a charter, and it's not a security agreement. They never get into that issue. So in a jurisdiction like the United States, which has the principle of if it walks like a duck and looks like a duck and quacks like a duck, it is a duck, that where recharacterization is used, that will succeed. And if you take a system with the flexibility of Marshall Islands and Liberia, they have the ability to do this. So what you have is unique in the shipping world. We don't even have it in the United States.
Right. Has a court recognized a recorded financing charter as a preferred mortgage?
Not explicitly in that way, but they have recharacterized long-term charters done on the BIMCO forms as being security agreements for loan transactions and not true leases, and essentially finance leases. And that has left the lessors unsecured creditors in bankruptcy, which is not a good place to be. And that's been held in the Fifth Circuit here. But I think you have to take a longer view on it. No courts these have only been around for 7 years. No courts have really had an opportunity or any interest in looking at this because the issues haven't been joined on it. But when you look at it historically, what are the prospects for this? Well, back in the 1980s, we looked at the rise of bareboat registries. And there was a huge hue and cry over the idea that these were unlawful dual registries, which were a violation of international law and convention. And the distinction was made that this is a registration only of a charter and not of the underlying vessel. And slowly over time, courts dealt with these and recognized situations just by reference in their factual conclusions that these were bareboat registered vessels, and not saying anything remarkable about it. In fact, now there are international conventions which allow for the position of bareboat registries and discuss how they will be unwound in the case of arrest and foreclosure and transfer. So this is the way I think that the financing lease exceptions and provisions will be regarded by the courts. There's no reason to think that wouldn't be so. And that would be the most consistent way to interpret them in the context of a system that has long recognized this product in aircraft finance and rail finance and container finance.
Right. Do you want to add anything to the
No, well, I think Frank has very succinctly described the current state of play. One thing that I do recognize being out here in Singapore versus in my prior life in New York, working with Frank, and is this conception that, oh, my documents are governed by English law, so I don't really, why is this even relevant to me, right?
Right.
And I think what can get lost in that line of thinking is going back to sort of the situations where our assets that we deal with are truly international. They do move. They're not restricted to a particular jurisdiction. Two, because of what Frank mentioned of the forum shopping, of the sort of the bankruptcy tourist aspect, it really brings to light the issues that we face today, where you do see a lot more bankruptcy filings in the U.S. So even if the documentation are governed and it's contractually agreed to be English law, the courts can simply say, well, as an equitable, I have in my jurisdiction as an equitable sort of discretion,
Right.
that I will recharacterize that lease as a financing document, and then I will look to English law to tell me how to interpret what I've recharacterized is now is a loan document, right, rather than a charter. So I think it's we can't simply assume that because we're using another governing law in a documentation that analysis is complex, but it's not a fail-proof way of avoiding a recharacterization issue, especially if your vessels do travel to the US or your ship owners or your lessees in this context would be inclined to file in the US, which they probably would, I would expect, because of the broad nature of the US bankruptcy sort of reach. I thought that was perhaps something that I would mention here, because it's the misconception, I think, that somehow because I have an English law governed document that I can this is something that's irrelevant to me, and that's really not the case.
Right.
Thing I'd like to add is just a reference to the Monty Python skit on the philosophers, in which one says to the other, after being reminded of real life cases and the reality of things, he says, "You're rather fond of real life." And really, that's really the question here. Remember that if a ship owner ends up or a charter ends up in a bankruptcy in the United States, or a vessel is arrested in the United States and then eventually finds its way to this same process, the judge in that case is not just looking at the situation between the lessor and the charterer. He's looking at a lot of other claims in that vessel by a lot of other people who will say, that's good for you, you agreed on English law or some other body of law.
Right.
But we're all here and we have an interest in here, and we didn't agree to be governed, have our claims governed by English law. So basically, we're going to insist on reality. And I think that's the approach that really makes this an important factor to hedge against the risk. One thing I think, G, you might want to add on to, because I think it's important, is the idea of the precautionary filing and the language that you very often find in charters that say, we believe this is a true lease, a true charter. But in the event that it is not considered to be a true lease or a true charter, then the charter grants us a security interest and we are a secured party. That is also a very common situation you'll find in some of these added clauses in the BIPCO lease where American lawyers have anything to do with it. And the idea there is, we don't know what the courts are going to say.
Right.
If they come up with the answer that this is not a true lease or not a real charter as opposed to a security agreement, then we have the protection of this filing.
Yeah.
Gee, I don't know if
definitely. Yeah, I think that's right, Frank. You do see it quite a bit in the context of other transportation equipment. In the aviation sector, for example, even when you know you're having an operating lease, and there's these precautionary filings, for example, filing in the US under the UCC laws, just in case that leasing arrangement does get recharacterized as a finance lease, then that lessor has the comfort knowing that all the filings for perfection purposes had been done. And if it's not recharacterized, then no harm done, right?
Right.
It's an operating lease, and they'll proceed accordingly. But in a bankruptcy scenario, if it does get recharacterized, you have the backstop needed to tell the bankruptcy trustee, the bankruptcy court, and make an argument that you've done everything you needed to do to perfect your security interest. And that's why precautionary filings is a very common action that's undertaken by lessors in the aviation context, and certainly in this context, it could equally apply, right?
Yeah, and I think it's important to note that the Liberian law actually indicates that just because you file a financing charter, it's not deemed a financing charter just by the act of filing it. So it still is reliant on the court to determine that. And that's the That's the important point. Question. I'm talking to a ship owner. How do I explain to them the benefits of recording a financing charter in my meeting with them? Or I'm talking to a lessor, having coffee with him. How do I explain to him or the lessor the benefits of recording a financing charter?
What are the dollar costs of doing a filing? It's relatively speaking very cheap. It's like an inoculation against the United States bankruptcy risk or any other recharacterization risk. It doesn't predetermine the issue of what the characterization is, but if you end up with the wrong answer in court, you have a big mitigation here. So for the lessor, I think it's an easy thing to justify, because he can quantify what the cost of that vaccine is.
Right.
When you talk to the ship owner, if he can look beyond it, he say, well, I'm not going bankrupt, so I'm not worried about this.
Right.
Or you could say to him, suppose they're especially smaller or medium-sized ones, or ones that have problem balance sheets, or who want to do leasing transactions because they're hoping that they can do something that's on a higher advance rate than 40 or 50%, which I think is probably the maximum even for grade A credits. Say, well, why don't you try to do a leasing transaction and to offer them this so that they don't have that risk.
Right. Right. It's an option so you can increase the return on the.
Yeah, but I would look at it from the lessor side. I would say it's an inoculation. You've got a vaccine against this risk, and that's certainly something that will resonate with everybody these days.
Frank and G, thank you for participating in this question and answer on financing charters. It's been very informative and useful. For those watching, if you or your clients have any questions about today's discussion or the recording of financing charters with the Liberian Registry, please feel free to reach out directly to me at ahmed@lisker.com. And also feel free to reach out to both Frank and G at fnolan@vedderprice.com and jkim@vedderprice.com. Thank you.